The court to lay down, it's very difficult because.
Very difficult then.
Very difficult. In fact, 10th schedule, each case is a history in itself. So therefore,
by virtue of the fact that the disqualification has not been decided.
I'm
So, is it the fruits of the poisonous tree are being enjoyed by somebody else?
I'm replying to your submission only.
I'm sorry.
That it should.
The stake in this case, Eknath Shinde, who is the chief minister, he is the first person, he is one of the 16. How will he going to relate back?
The Nabam principle is right.
Yeah.
Then once a notice is given of an intent to move a resolution to the speaker,
Yeah.
not on the 10th schedule, but for any other reason, so long as the motion is pending.
That's right. The motion is pending. How does that? How will this argument be? You will then have to make a distinction under 179 itself in interpreting 179 read with the 10th schedule.
No, but logically, Mr. Sibbal, the argument of the principle in Nabam will extend irrespective of what the cause for the.
I agree, but that's what I'm arguing.
Yeah, that's right.
That's precisely what I'm arguing.
Because once the principle which Justice Mishra seems to have laid down
Yeah.
is that once, and Justice Kher also, that once a notice for your removal is given,
Yeah.
then then there is a.
But there is a
Except for one thing, I'll tell you what.
Yes.
In case of the 10th schedule, there's one additional factor. That when the speaker acts to disqualify somebody under the 10th schedule,
Yes.
he is affecting the majority in the electoral college, which will decide upon his removal. Right?
Correct. But that's fine.
Suppose a speaker is supposed to be sought to be removed on the ground that, well, for whatever behavior in the house. They say that, well, you have not given the opposition sufficient time to speak, or you have not been even-handed. Just
Correct.
Hypothetical.
Correct.
In that case, there is no conflict of interest as such. That conflict of interest is taken care of by 181.
Yes.
Namely, that on that day when the motion comes up for consideration, you will not preside. You will have a right to
That
vote.
is motion to remove him.
Motion to remove.
Absolutely right.
But there's no question of the speaker affecting by excluding certain members of the legislature.
I agree.
Because here what happens is the moment you rule on the disqualification, you are affecting the balance or composition of that body which will vote on.
I agree entirely with your lordship. Therefore, but 179 will still have to be interpreted in any situation. You can't ultimately you'll have to say that 179 in this context will not operate.
No, that you see the Constitution lays down the principle in regard to the overall conflict of interest in 181.
Yes.
Irrespective of whether it's on the 10th schedule or otherwise.
I am saying that.
But on the 10th schedule disqualification, our court has introduced an additional.
But that's the problem. That is the problem of the case. But
your argument, Mr. Sibbal, your argument that the same principle will apply to any motion for removal may not strictly be right.
But that the Nabam Rabia doesn't say so. Your lordship may interpret Nabam Rabia like that. But Nabam Rabia doesn't say so. We are now saying you will have to clarify it. You clarify it by referring to 7. I'm on the principle. I'm not arguing the merits here. I'm on the principle. Nabam Rabia doesn't make that distinction. Your lordships may wish to make it. That's another issue. But let me just move. This is one issue. Number 2. But in fact, 179 was incorporated in the Constitution for the removal of the speaker because removal involves a stigma for cause. And therefore, you will see in the constitutional provisions his right to participate in the House and defend himself. It was nothing to do with the 10th schedule. You see the provisions 179, 181. He will, at the time when the motion is moved to remove him, he'll preside over the House.
Actually, you're right. 179 and 181 have nothing to do with the 10th schedule.
Exactly.
Because that's why when the 10th schedule came in by the 50th constitutional amendment,
yes,
they recognized that in 191.2 and 102.2.
That's right.
But they didn't amend the provisions of 180, 179.
That's correct. That's correct.
They left it intact. What's the reason? Parliament left it intact.
There's a reason why they left it intact. See the proviso.
We have got several members of Parliament over here in any case. Normally, when a 10th schedule petition comes for disqualification, the 10th schedule itself doesn't indicate how much notice has to be given to the member.
No.
Come under the
That
rules.
will come under the rules.
Under the rules.
And every legislature.
That is why courts have said rules are not mandatory, Malaz. I'm not on the merits, Malaz. My learned friend argued the merits. We are not on that.
I was not on that. I was for another reason.
Yeah.
That technically, then a speaker, the next day after a petition for disqualification is presented to him, in a day or two, he can say, I'm disqualifying you, right?
Yes.
Technically,
Technically
a speaker may do that.
That he can. I tell your lordship the reason. I give your lordship the reason. Supposing, Malaj, the house is proceeding, a whip has been issued, and 12 people defy the whip. Just because these are live examples. 12 people defy the whip. Now, Malaj, what's the need for a notice? It's on the record.
It's like contempt in the face of the court.
Exactly. It's on the record. Somebody files an application that I'm seeking a removal. So under Nagan, he can't deal with it.
But then the legislatures have made rules, provided that the 7 days notice is to be given, though it's interpreted as
Not
Kapil
mandatory.
Sibbal is saying.
Normally it is 7 days.
But then there is a Karnataka judgment, a 3-judge bench.
Then Ravi Nayak.
You know, it's not Ravi Nayak. It's Shantanu Gowda, Justice Nazir, and Justice Boppana.
Yes.
All three of them have come here. The question there was whether 7 days notice, 7 days was not given. But then the court held there
3 days enough.
that not necessary. But then this court has reversed it in a subsequent judgment. This court has held, the legislature has made a rule, 7 days.
That's Yediyurappa.
Has to be followed.
That's Yediyurappa. That's been distinguished in another case. But Manoj, as I said, we are entering into the merits of these issues, which we are not at the moment concerned with.
You must be aware.
No, it has one very important bearing.
You only made rule.
That why do you attach the disability on the speaker the moment a notice under 179C can be given? The reason is that there is no real power or restraint on the speaker in proceeding with the greatest of alacrity on the disqualification.
But on the other hand, Manoj, when there is a disqualification,
That seems to be the logic.
that's fine. But on the other hand, when there is a disqualification,
It's so difficult, it depends.
what has happened today is, Manoj, somebody goes to Gujarat, goes to Assam, passes resolutions, removes people, Manoj, and that is not considered to be
That my
disqualified.
learned brother just mentioned, if with his permission I'll share. It's not always that the speaker will act with alacrity to disqualify. In a given case, he will be sufficiently emboldened, or he may decide not to take a decision also.
That's right, Manoj. We have seen that in Goa. We have seen that in many other places.
It works. It
When
depends on
Manoj,
which
it
way.
depends on who is in power.
Exactly.
Exactly. So, Manoj, therefore,
Sometimes you want to take an early decision.
Manoj,
Sometimes you have to
For a
let.
court to lay down, it's
let-
very difficult because,
Very difficult then.
very difficult. In fact, 10th schedule, each case is a history in itself. So therefore, to formulate a principle with respect to at what time the speaker is to act and lay down as a principle is difficult, because, but then legislatures and parliament has made rules with respect to when he should act.
no,
But
Manoj,
discretion is a problem.
Manoj, in
In one
fact,
case, he will act.
the moment
contrary.
we're only concerned with one issue, whether at the time of issuance of notice, the disqualification to preside occurs. That's the only issue we are concerned with. We're not concerned with any
Then
other
which
issue.
is probably only answer to it is whenever at whatever point of time the case is finally decided by the speaker, it will relate back.
Yes.
If it relates back, all this is irrelevant.
No.
If it relates back, all this is because even now.
No, it won't relate.
Take in this very case, Mr.
Manoj, in the
If he
meantime,
decides today if your argument is to be accepted, it always relates.
Manoj, but in the meantime, a legally elected government has been toppled by virtue of the fact that the disqualification Manoj, has not been decided.
I'm
So, Manoj,
giving
is
an
it,
answer to your-
Manoj, the fruits of the poisonous tree are being enjoyed by somebody else?
I'm
Manoj?
replying to your submission only.
I'm
that-
sorry?
That it should relate back to that. I'm saying the answer.
No, that's all right, but it will relate back after 2 years, relate back after 3 years.
Relate back, because I argue in the context that your lordship would then allow a disqualified MLA or MP to be able to do something. If it relates back, that is the person who is given the notice is himself disqualified. He can't, that is the context in which it is argued, that your lordship cannot then allow him to have the status of a person who can give a notice.
Well, let's take in this case Eknath Shinde, who is the chief minister. He is the first person, he is one of the 16. How will he going to relate back? In the meantime, a government has been toppled. So, these are very vexed questions that your lordships will have to look at Raman Bebia and see how to answer them.
Mr. Sibbal, there's another aspect also of Nabam which has been worrying us. We've been in discussion, which is that ultimately in any constitutional adjudication, Nabam lays down a principle. Now, we have seen how vexed it can be in the sense that, it really depends on the emerging political situation from case to case, states to state to state.
That's true.
Now, Nabam has laid down a principle which is holding the field until today.
Yes.
Before we decide to enter upon this to review the correctness of Nabam, we must also be clear that it strictly speaking arises in a case. Now, one thing which you have to really perhaps assist us on is this. Nabam, the correctness of Nabam would arise if the speaker stood injuncted either by the High Court or by this court from exercising his powers under the 10th schedule. If the speaker was injuncted from exercising his powers under the 10th schedule until the vote for his removal was taken up.
Right.
Or he himself says that, look, in view of Nabam, I'm not going to exercise my jurisdiction.
Right.
Then somebody else may say that, well, you have to exercise that jurisdiction. Now, in our case, what happens is that when the speaker perhaps in that sense created a problem for himself, maybe out of the political exigency. We're not at all saying that in a pejorative sense. That's real politics. The speaker himself gave only 2 days notice. 25th, he said, I'm going to give you time until the 27th. Our court, in the light of that, said that time to furnish your reply is extended until the 12th of July.
In the interim, your lordship may not have looked at that phrase.
Yeah, in the interim.
In the interim,
Now,
it is extended.
time a trust vote takes place.
Yes.
The then government decides not to face the assembly, it resigns.
Right.
Therefore, what impact the vote or non-vote of these people who were sought to be disqualified by the speaker would have was never tested on the floor of the House.
No, it on the 4th it was tested.
The resignation.
On the 4th it was tested.
No.
Yes.
On the resignation of the chief minister obviated a reference, obviated the floor test.
No,
Therefore,
it happened. It happened on the 4th.
On the 30th itself.
For Shinde it happened, the same thing.
No, but on the 30th, what happens is this. On the 30th, when the floor test is to take place, the government resigns on the 29th.
Right.
The moment, of course, they got to know that the floor test is going to be held and there's no stay by the Supreme Court. Now, as a result of that, what happens is that the consequence of the vote, which would otherwise have been cast by a person who was sought to be disqualified on the overall voting pattern, never emerges before the assembly. So, in which case does the correctness of Nabam Rebia fall for consideration?
Yes, Manoj, I will demonstrate that immediately.
And should we go into the validity of Nabam Rebia merely because obviously very interesting constitutional issues arise? Because